So hello, everybody, and welcome. I'm Lisa Burkhardt. I'm the current president of AACA. I'd also like to welcome our partners at Hall Benefits Law today. Thanks to everybody at Hall for all of your support to AACA over the years.
I would like to introduce both of our speakers today. Our first speaker is Ann Tyler Hall, and she is the founding attorney principal at Hall Benefits Law. And prior to forming HBL, Ann Tyler Hall practiced ERISA and employee benefits law with Alston and Bird LLP and King and Spalding LLP. As a business owner representing businesses, Ann Tyler and her team of experienced ERISA attorneys understand firsthand the importance of strategically designed, legally compliant benefit plans aimed at attracting, motivating, and retaining top employees. She and the HBL team also know the importance of responsive and timely legal compliance guidance to businesses who are in 6- and 7-figure IRS, Department of Labor, Department of Health and Human Services penalty situations. Since January 1 of 2018, HBL has avoided or abated more than $70 million in proposed penalties for plan sponsor clients, working closely with the trusted advisors serving these clients. So we are very, very lucky to have Ann Tyler with us today. And then for our next speaker, Jennifer Harris. So Ms. Harris is a labor and employment attorney with 2 decades of experience in ERISA and employment law, most recently serving as a de facto in-house counsel for one of the largest consumer specialty finance companies in the U.S. HBL clients can count on Ms. Harris for all things employment law, including working closely with and advising related departments and executive management on compensation and benefits, recruiting and staffing, performance management, learning and development, and employee relations and conflict resolution. So she is well versed in it all. So without further ado, I will turn it over to Ann Tyler.
Thank you so much, Taki. It's great to be with you today. We're excited to share with you. It's been a busy past 18 months, past 6 months in benefits legislation and employment compliance guidance and legislative action that impact employment law. So if you have any questions, we are going to open it up for Q&A after each of our sessions. But if you have any questions that don't get answered today, and also we regularly post guidance on legislative happenings, new law that impacts ERISA benefits and employment compliance. If you would like to join us or to be on our email distribution list, please go to our website, www.hallbenefitslaw.com. And sign up for our newsletter, and we do regular updates. And then if you have any questions that don't get answered today, please do not hesitate to reach out at admin@Hall Benefits Law, and we will circle back with you and touch base with you to address those questions. So without further ado, I'm going to jump right in. Today we're going to be talking about just a litany of legislation, the recent bills that have impacted both employment and benefits compliance. So today for my presentation, my portion of the presentation, I'm going to do a high-level overview of the changes under the Secure Act, primarily impacting retirement plans. This was signed into law at the end of December 2019. And then primarily focus on the past 3 to 6 months, the Consolidated Appropriations Act 2021, that will be referred to as the Act, and the American Rescue Plan Act 2021. I'll also refer to that as ARPA. So we'll jump right in. Changes under the Secure Act. Just wanted to give you the enormity of the legislation that has impacted benefits since December 2019. So in the past 18 months, We saw the Secure Act pass at the end of, signed into law by President Trump at the end of December 2019. This was the biggest piece of legislation impacting retirement plans since the Pension Protection Act of 2006. So almost 13 years then since we'd seen a body of law, a piece of legislation with such broad and deep impact to retirement plans. You'll see the litany of changes that took effect at the beginning of 2020. Hopefully your company was on top of these issues and has been complying with these requirements. I won't go into any depth, just wanted to give you an overview of just the litany of changes that became effective immediately at the beginning of 2020. And then I also wanted to touch base on the changes that take effect this year or in 2022. The first is the prohibition on part-time employee exclusions. This was a significant change to primarily 401k plans. So the rules had been that if you achieved 1,000 hours of service, the rules prior to the changes in the Secure Act, if you were an employee and achieve 1,000 hours of service during the year, you have to be allowed eligibility to make elective deferrals into the plan. The Secure Act reduced that hours requirement to 500 hours. And so we're seeing a lot of our employer clients who are now having to open up, potentially open up eligibility for deferrals in their 401k plans for employees that work only 500 hours during the year. Now, the nuance of this is that this counting begins in 2021, and those individuals must achieve at least 500 hours per year for 3 consecutive years. So the first year that we're going to see this real expansion of eligibility is 2024. But that's a big change to retirement plans and impacts a lot of employers with part-time workers, with seasonal workers who might achieve in a given year 500 hours of service each year for 3 consecutive years. The other thing that I wanted to mention is pooled employer plans. This is an attractive option and essentially an open multiple employer plan option for smaller employers. And we're getting a lot of questions around pooled employer plans as an alternative for some smaller employers. I did also just want to mention item number 3 on this list, increase in failure to file retirement plan returns timely. The IRS increased, so in the Secure Act, there were many provisions that were tax favorable for participants, for employers. And what Congress giveth, they also taketh back. And they took it back or paid for the Secure Act with the provision related to the increase in the failure to file retirement plan returns timely. This applies to your Forms 5500 for your retirement plan, your Forms 5330, your Forms W4, and your Forms 8955 SSA. So all of those are included in this increase, this penalty increase, and the penalty increase is tenfold. So whereas in prior to the Secure Act, the failure to file a Form 5500 was $25 a day, up to $15,000. That is now $250 a day, up to $150,000. So significant repercussions for failure to timely comply with the annual and other return requirements for retirement plans. So I did just want to point that out. That became effective at the beginning of 2020. So Secure Act, just a high level overview of some of those changes. Some of those were effective immediately in beginning of 2020. Some of those take effect in 2021 and beyond. We'll jump in now to the Consolidated Appropriations Act of 2021. This was signed into law at the end of December, and it includes certain provisions affecting health and welfare benefits and also employment compliance. But today we'll talk about the health FSA relief in the Act, optional limited extension of emergency paid sick leave under the FMLA, retirement plan partial plan termination relief, the prohibition on surprise billing, broker compensation transparency rules, and the mental health parity transparency disclosure requirements. So jumping right in, the Act allows for FSA participants to carry over their entire unused amounts. This is a temporary expansion. Previously, as you'll see in the second bullet, there was a provision that allowed participants to carry over $550, but not the entire amount, not the entire, for instance, $2,750. And so for the plan year ending 2020, if a participant has, for instance, $1,000 health FSA balance, they can carry that over to 2021. The Act also provides for a carryover for 2021. So if you have an excess amount as a participant in 2021 and you want to carry over that balance to 2022, you are permitted to do so. Now, the employer has to elect to offer this option and expand and elect this expansion. And if they do, if an employer elects this expansion of the rollover provision, this does supersede the existing $550 carryover limit, understandably. It also then enables carryovers for dependent care FSAs. So these same types of carryovers are allowed for dependent care FSAs, and we'll talk about that in a later slide. FSAs may also allow for grace periods of up to 12 months for plan years ending in 2020 and 2021. And this relief is available for both calendar and non-calendar FSAs. Also, a very generous spend down feature for former employees. So prior to the Act, and this is for 2020 and 2021, at this point only, it'll be interesting. I'll just make a note. These changes are temporary. We'll try to note the years in which these expanded rules apply. Will be very interesting to see whether these expanded provisions are made permanent. And so we'll keep here at HBL, we'll keep writing and speaking about new legislation and whether the Biden administration, whether Congress votes to then expand these provisions permanently. But at this point, the spend down feature for former employees available for 2020 and 2021 only. Former employees prior to the Act, if you didn't use as a plan participant your entire health FSA balance by the end of the year and any grace period, then you lost that benefit. It's the use or lose rule, so well known in the cafeteria plan rules and regulations. But for 2020 and 2021, an employer can allow via their cafeteria plan to allow former employees who didn't use their full balances to continue to pay for qualifying medical expenses through their health FSA through the end of the plan year. Another big change under the Act is an increase in the dependent care FSA age limit. And so DSFSAs generally provide that when a child turns age 13, they are no longer eligible, and the participant is no longer eligible to pay for those child care expenses once the child turns age 13. So the Act expanded that to allow for children who turned age 13 in 2020 to continue, that the participants would continue to be eligible to pay for their child care expense, even if the child turned age 13 in 2020. And I gave an example here at the bottom of the slide. Also, the Act extends this relief to 2021. And if the dependent care FSA participant has an unused balance at the end of the 2020 plan year, and the participant turns age 13 during 2021, In that instance, the limiting age increases to 14 years old for 2021. So a further expansion for 2021 if a dependent care FSA participant has a child who turns age 14 for 2021, they may still use any unused balance from their dependent care FSA would remain available to pay for these remaining qualifying child care expenses. So just a note that this relief only allows prior balances to be used. It does not allow for a prospective election for a child who has already achieved age 13 or older. But any unused balances can be used for children who achieve age 14 during 2021. I'm going to let Jennifer Harris jump in because this is more of an employment compliance issue to talk about the optional extension to paid sick leave under the FMLA, extension of the FICRA.
First of all, I'm happy to be here. Second of all, technology is not my thing, so I hopefully we'll do better as we go forward. Thanks for passing it off, Ann Tyler. So talking about FICRA, as I'm sure you all recall, the FFCRA was originally signed in March of 2020 by former President Trump. As originally signed and enacted, it was required certain employees, certain employers, private employers under 500 employees, and public employers to provide two types of emergency leave options for their employees to be offset by an emergency tax credit. Those were emergency paid sick leave, or EPSL, and emergency family medical leave, or EFML. As mentioned, it was initially enacted as mandatory, and those that was in place from April 1st of 2020 through December 31st of 2020. I think many expected that President Trump would extend this into 2021, but he did not. What he did was he extended it as a voluntary program beginning January 1st, 2021 through March 31st. And that's what you'll see on the slide. So Biden did come and did the same with the APRA, extending it as a voluntary program, this time through September 30th of this year. He also made a couple of other tweaks that I'll talk about, but it's all still voluntary. If an employer wishes to provide FICRA leave on a voluntary basis, the tax credit remains at play. So what are the tweaks that were made by APRA? No additional periods of leave have been provided, but the statute did the following. It reset the emergency paid sick leave 10-day bank beginning on April 1st of 2021. And it added 3 new criteria to the EPSL related to receiving a vaccine and side effects of a vaccination. It also added non-discrimination rules into the mix. And as to the EFMLA, the entire 12 weeks is now paid leave as opposed to just 10 weeks of that. And the tax credit associated with that has been increased to $12,000. There are some important open questions, and I will say that these are open questions. Do employees get a new bucket of the FMLA as of April 1st? It seems like they do. Should an employer count EFMLA against the 12 weeks of regular EFMLA? There's just simply no guidance right now yet on that subject. So we'll have to keep an eye out to see how that evolves.
Thank you, Jennifer.
Thank you.
Continuing on, the Act also provided for some key retirement plan, partial plan termination, temporary relief. Under the partial plan termination guidance from the IRS, generally, if you have a 20% or more reduction in workforce, you potentially have a partial plan termination, and all employer contributions must be fully vested for those impacted participants. So a potentially significant cost to plan sponsors, to employers. And in the past year with COVID, with particularly in, for example, the restaurant industry or the hospitality industry, where there were mass layoffs, this was an ongoing concern. I know we did several partial plan termination analyses over the last year. And so some welcome relief from the Act, from Congress. If So essentially, the temporary relief provides that a plan is not treated as having a partial plan termination if at the end of the relief period, which extended through March 31, 2021, again, going to be interesting to see if Congress extends this relief period. I think they probably will. We haven't gotten any guidance on that, but we're likely to in the coming months. But at this point, it was the relief period ended March 31. If the number of active participants covered by the plan was at least 80% of the number of plan participants covered by the plan at the beginning of the relief period, basically the beginning of COVID, March 13th, 2020, then a partial plan termination is not treated as having occurred for that plan. And some nice flexibility in that 80% calculation. The plan participants who count towards that 80% requirement do not have to be the same original terminated employees. So we were recommending that our employers who might have been at 75% of their pre-COVID employment plan eligibility comparison, that they go out and hire some employees and make those employees eligible immediately for the retirement plan to avoid a partial plan termination, which once again, depending upon the retirement plan design, can be quite costly if an employer is then required to immediately vest all participants affected by the partial plan termination. So some welcome relief on the retirement plan side. Continuing on, there was a provision in the Act that prohibits surprise billing. Specifically, it provides that patients cannot be balance billed for out-of-network emergency services. So this protection applies from the initial evaluation until stabilization, when the patient can consent to a transfer to an in-network facility. This protection applies to both out-of-network facilities and out-of-network providers, air ambulance services, but not ground ambulance services. So no surprise billing for out-of-network emergency services. Additionally, patients can only be balance billed for non-emergency services performed at an in-network facility by an out-of-network provider under certain circumstances. Patients can waive these protections by consent if they're notified at least 72 hours in advance of the care. And the no surprise billing prohibition includes additional limitations and restrictions related to cost transparency, disclosures, and the inclusion of in-network and out-of-network deductibles on insurance cards. So some big changes for surprise billing. Now, this does take effect beginning January 1, 2022. So employer plan sponsors, you have a little bit of time to prepare for this no surprise billing prohibition included in the Act. Broker compensation transparency rules. So if you have a health plan, whether it's self-funded or fully insured, you likely have a broker. And if you have any decision-making authority over the health plan, then you are considered a plan fiduciary, and you have a duty to understand the arrangement with your insurance brokers, including both the direct and indirect compensation that your broker receives. And so just a note that where your broker is paid solely in commissions, that's not truly free to you and to your plan participants. Those commissions are made up in other costs to the plan. So the Act added additional requirements regarding broker and consultant arrangements and compensation. Now, it's unclear whether these transparency rules apply to single employer health plans or multi-employer health plans only. We should be getting additional guidance in the coming month. If they do apply to single employer health plans, this is a big transparency requirement and an additional, I guess, reason for plan fiduciaries to make sure that they understand their health insurance brokers' commissions and how those impact health plan costs. That is a plan fiduciary responsibility. Lastly, the Act made some significant changes to the mental health parity transparency rules and disclosure requirements. And this became effective almost immediately. So beginning February 10th of this year, group health plans and insurers are required to provide certain information related to mental health parity compliance. And so there's this non-quantitative treatment limits that must be the same or comparable for substance use disorder, for certain mental health parity coverage items. So one of those being substance use disorder must be comparable and no more stringently applied than for medical or surgery benefits. Under the Act, plans are required to perform and document comparative analyses of the plan design. So some significant new requirements, disclosure requirements. And group health plans are required to make this compliance documentation available to the Department of Labor, Health and Human Services, or any applicable state authorities upon request. Again, this change was effective basically immediately, February 10th. So if you aren't preparing for how you're going to, particularly if you're a self-insured health plan, how you're complying with these new mental health transparency rules, it's advisable that you speak with counsel to prepare and put in place a paradigm for complying with these new mental health parity, transparency, and disclosure requirements. Some significant repercussions for non-compliance with these new rules. If the plan is found to be non-compliant after a 45-day correction period, the plan must inform participants that the plan does not comply, and the Department of Labor will identify non-compliant plans in its annual report to Congress. So very important to be aware of and putting in place a compliance paradigm for the mental health parity transparency requirements. We'll jump in now to the American Rescue Plan Act of 2021. I'll refer to that as ARPA. Some changes under the ARPA. This was signed into law on March 11th of this year. Benefits provisions include a 6-month, 100% COBRA premium subsidy for certain former employees, an increase in dependent care FSA exclusion limits for 2021, actions to address solvency concerns for both single and multi-employer pension plans, an expansion of the covered employee definition under Code Section 162M, and a voluntary extension for FFICRA extended through September 30th, 2021 that Jennifer mentioned a little bit earlier in the presentation. So the big change includes this COBRA subsidy provision. ARPA creates a 100% COBRA premium subsidy for any period of coverage during the period beginning April 1. So that started just a few weeks ago through September 30th of this year. The premium subsidy also covers any administrative fees and is available for any employee or dependent who loses group health plan coverage due to an involuntary termination of employment. We're still waiting for guidance on what is the definition of an involuntary termination of employment. If you have any questions about that, consult with counsel, because again, this became effective 2 weeks ago. And that individual elects COBRA coverage. So an involuntary termination of employment and the individual elects COBRA coverage. So the employer is responsible for paying the premium for these individuals and then will recoup these expenditures through tax credits on their quarterly payroll tax returns, essentially a credit on the Medicare tax. And if the subsidy is actually higher than the payroll taxes paid by the employer will receive a refund. ARPA, to note importantly, does not extend the COBRA coverage period. So the COBRA coverage period does not change. It just provides a 6-month, 100% COBRA premium subsidy for those individuals, eligible individuals who are involuntarily terminated from employment and elect COBRA coverage. The Act also provides for a look-back period dating back to November 2019 for individuals, eligible individuals to elect COBRA. It's an 18-month look-back period, and it's a special election period for any individual who either did not elect COBRA continuation coverage between November 1, 2019 and April 1, 2021, but who would have been an eligible individual if such election had been made, were elected COBRA coverage and discontinued such COBRA coverage prior to April 1, 2021, or an individual who is allowed to elect COBRA coverage. And just to note, those are the two eligible individuals. The individuals are allowed to elect COBRA coverage within 60 days of receiving the required extended election notice from the employer. And we just got those model notices, I believe, this weekend. ARPA also permits a plan to provide an eligible individual the opportunity to change their health coverage options in conjunction with electing COBRA coverage. So an eligible individual may elect to enroll in a different group health plan within 90 days of the date of this enrollment option and receipt of the notice. So this additional notice, again, we got the model notice I believe this weekend. The Department of Labor released the model notices. You as an employer then need to be working with your third-party service providers, or you may be responsible for the provision of this notice that accommodates these ARPA changes to COBRA coverage. ARPA imposes these additional notice requirements for individuals who become eligible to elect COBRA from April 1 until September 30th. And this notice also must be furnished to eligible individuals if such individual became entitled to elect COBRA coverage on or after November 1, 2019 and prior to April 1, 2021. Going to be very interesting with respect to the look back period. We expect to see a lot of adverse selection. But with that, Jennifer, I know you had some additional gloss to add to this, to these changes.
Yeah, all I was really going to add is, as you mentioned, the model notices were published by the Department of Labor, I believe, late last week or over the weekend. So I have put in the chat box a link to where you can find those, as well as some FAQs that they published that might be helpful.
Excellent. Thank you, Jennifer.
Sure.
Additional changes under the ARPA, a temporary increase to the dependent care FSA limit. Those of us with young children, this was a welcome change. Now, this is, at this point, only temporary. For 2021, that the limit increases from $5,000 to $10,500, or half that amount in the case of a separate return filed by a married individual. And similar to the dependent care FSA changes under the Consolidated Appropriations Act, this is a permissive change. Employers are not obligated to increase the election amounts, but a welcome relief probably for many employees, and a recommended change for plan sponsors. Additional amendment requirements here at the end of slide 34. I won't go into those, but the plan must be amended to accommodate these changes. I won't go into too much detail around solvency relief for pension plans. If you have a single employer pension plan or a multi-employer pension plan, some welcome relief, solvency relief for those pension plans. We don't see many pension plans this day and age. Most of them are frozen or they've been terminated. But those that haven't, many are in financial dire straits. And so this the COVID didn't help with that. And so the ARPA provides some special financial assistance for both single employer and multi-employer pension plans. The final provision that I wanted to talk about today in the ARPA is this expanded class of covered employees under Code Section 162M. So 162M, Code Section 162M, applies to publicly held companies, and it limits the deduction that publicly held corporations can deduct with respect to compensation for certain covered employees. So it limits the deduction to $1 million per year for compensation paid to covered employees. And so ARPA expands the definitions for tax years beginning after December 31, 2026. So this is several years out, beginning for tax years January 1, 2027 and onward. A covered employee also will include now the 5 highest compensated employees, in addition to the already existing covered employee definition, which includes the company's principal executive officer, the company's principal financial officer, and the 3 highest compensated officers for the taxable year other than the PEO or PFO. And so the ARP expands this to include additional highest compensated employees. And these individuals do not have to be officers of the publicly held corporation, just have to be the highest compensated in the organization. 162M provides that once an individual is a covered employee for a taxable year, they remain one for all future taxable years. That's the general rule. This does not apply. This requirement does not apply to the additional 5 employees whose compensation is subject to 162M as a result of ARPA's expansion. With that, I will turn it over to Jennifer, but I'll pause for just a minute to see if anyone has any questions.
And Tyler, there was a question early on about the carrying over of the FSAs. Just why would a company not carry over?
It's a good question. There's really no reason not to allow for this carryover. It's beneficial to your participants. It's a great way to communicate to your participants that you are availing, you as the plan sponsor are availing the company and thereby helping participants as they weather the financial difficulties related to COVID and allowing for that expanded rollover provision. There's really no reason not to allow it other than you need to comply with the amendment requirements and make sure that you comply with the notice requirements and that all of your participants are then aware of this expanded provision. So that's the obligation to the employer. There is a compliance obligation. You have to amend the plan. You have to provide notice. But our opinion would be that that's well worth it to provide the expanded rollover capability and provisions for your employees. Great question. With that, I will turn it over to Jennifer. I know there's a lot to cover on employment compliance.
Thank you so much, Ann Tyler. So just to sort of wrap up ARPA, we already talked about the modified employee entitlement under FCRA. The only other thing I wanted to mention here is that the federal unemployment insurance benefits have been extended again. These are the 3 different types. Given how crunched we are on time, I won't go through them, but I'm certainly happy to answer any questions about them. They have been extended at this point through September 6, 2021. So that's important to know. Okay, so what else? Obviously, I have quite a few slides here regarding the WARN Act because I know that that's a really important area that's come up over the last year and hopefully, optimistically, will not be a big issue going forward, but I want to make sure everyone's prepared. It's really complicated and there's a lot of slides here. I'm not going to go through all of them, but I wanted to, because it's so technical in nature, give you guys sort of some of the key definitions on this slide so you have it for reference purposes if that's helpful. So what is the WARN Act? The WARN Act is, you've probably all heard of it and likely experienced it firsthand, particularly since the pandemic. The federal statute passed in 1988 with the intent of helping communities be prepared for large-scale employment losses within the community that could occur. So simply put, under the WARN Act, covered employers are required to give 60 days advance written notice of an upcoming plant closure or mass layoff to its employees. I know those of you that have dealt with this realize that it sounds really easy, but as written and with the regulations, it's very technical and can be hard to follow and anything but intuitive. So what makes it so tricky? The statute and its implementing regulations, like I said, are fairly convoluted. And the definitions used for some of the most basic terms, the terms that flow through the statute, are not intuitive. For example, to determine if an employer is covered by WARN to begin with, and then also if notice is required in a given situation, the employer needs to determine how many employees were employed by it at a given time, which is generally the day that notice should have been given, if notice is determined to be required. And then also for employment loss purposes. For the employer coverage calculation, there are two options provided, and for both, you exclude part-time employees. You also exclude part-time employees in determining the plant closure or mass layoff thresholds. So why is this important and why am I telling you this? I'm trying to just sort of highlight some of the trickier areas with determining if warrant applies, and this is one of them. Part-time employees are uniquely defined under the statute and the regulations to not only include employees who work part-time in the traditional sense, fewer than 20 hours per week, but also newly hired employees. So those employees that have been employed with the company for fewer than 6 of the 12 preceding months. As of the date, notice would have been required. So there's a lot of math, there's a lot of calculating. It's not nearly as easy as it could be. Other pain points within WARN, while the employer coverage component is fairly straightforward except for the part-time thing. You also have to determine whether your proposed course of action is a covered plant closing or mass layoff, as those terms are defined. Because the statute was originally written to assist communities, the threshold numbers for these are not based on the employer as a whole, but as to a single site of employment. Sounds straightforward enough, but a single site of employment can refer to a single location, but it can also refer to contiguous locations such as a campus or an industrial park, or even separate facilities across the street from one another, or even separate buildings in areas which are not directly connected or in immediate proximity, but may be considered a single site if they are in reasonable geographic proximity, are used for the same purpose, and or share the same staff and equipment. So the regs in the case law provide additional guidance on these points, but it's really a case-by-case analysis, depending on the employer's setup and the proposed reduction in force. So once you have your single site of employment determined, you can begin to determine if the threshold losses will be met. So that, I know we're still on the same side. Sorry, Ann Tyler, it's a long one. So it seems like you would just look at your proposed layoffs to determine if they meet the threshold numbers, 50 or more at a single site of employment for a plant closing. Same for a mass layoff if that's at least 30% of the employees at that location, or if it's 500 employees, the percentage amount doesn't matter. Again, this also excludes part-time workers. So there's some figuring there. You have to exclude certain people, and you have to determine all of that as of the date that notice should have been given, which would be 60 days before your first intended action. So the statute doesn't just take each reduction in force on its own. A lot of times these are rolling things. We'll make one action on January 1st, and then we'll have another planned action on February 1st, as you guys know. So the Act instructs employers to aggregate its actual and planned actions by looking at either a 30-day backward and forward period or a 90-day backward and forward period, depending on the circumstances. We'll talk about that a little bit more later. So I guess, I can go through all of these slides, and I'd love to have the time to go through all of these slides. And if this is a key area, maybe there'll be a time for me to come back. But I don't want to spend all my time on WARN, and we're already at 11:54. So I'm going to sort of fast forward and say to you guys, I provided some details into these slides, and I know that you're going to be given them as a resource after the webinar. So if you have any questions, this is a very complicated area, to be candid. When I was in-house, sometimes I would reach out to outside counsel just to talk through this, because there are a lot of back and forth. There's a lot of math. There's a lot of what date, when do you use the 30, when do you use the 90, too much to cover here. So again, I'm a resource, but I want to go ahead and at least pick out some of the other key areas that I wanted you guys to think about outside of WARN. So I hate to rush through that, but, and again, I'm happy to come back. So Ann Tyler, if you can fast forward, yeah, there you go. So just want to make sure we don't forget about the other considerations when you're having a RIF. Obviously, you need to consider Title VII and make sure that the actions you're proposing don't have a disparate impact on a protected classification. And you want to look at risk mitigation opportunities, and that would be the use of severance agreements and making sure those severance agreements are written appropriately. There's a lot of specific laws that you need to think about. The ADEA has a 7-day revocation, and then you have to have a reasonable period of time. If it's a RIF, that has to be 45 days. There's a lot of other state law and specific considerations you need to think about. So make sure that when you're putting together your documents, you have someone review those if you need to. Counsel is always good for that. Next slide, please, Ann Tyler. Just a couple of other things. I'm not going to really talk about COVID immunity statutes because we're so tight on time, but you guys are probably really aware of those. They don't really apply so much to employees unless it's taken out of the workers' comp text, because the workers' comp still applies for employee injuries. One thing to note that the Georgia does have its immunity statute is unique with the posting requirement. It's currently scheduled, I believe, to go through July of this year, but there's a bill pending to extend that out an entire year. OSHA is also important. Employers have a general duty to provide a safe place for their employees to come to work. There's a lot of recently issued guidance. This is a big area of Biden enforcement. And he's put a lot of money into OSHA for increased on-site inspections. Vaccinations, we could talk about that for an hour on its own. A lot of things to think about there. I'm sure you guys have probably been to 100 seminars or webinars that talked about the 80 implications of talking about COVID and asking about symptoms. So now we're really focusing more on vaccinations. You know, can you have a mandatory program? Short answer is you can have a mandatory program for vaccinations as long as you have mechanisms in place to do the ADA interactive analysis for people that might need an accommodation to that, and also for religious accommodations. So the other couple of things I just want to put on your radar, again, not really enough time. I'm sorry to go through them in detail or to answer many questions, but here, and I'm happy to come back. Pay equity is a huge issue right now. Biden has said that it's one of his major focuses. He's been very transparent about that, and we expect that this priority will be shared by incoming agencies who are tasked with setting their investigation and enforcement priorities in line with the administration. Also important to note is that several states have already implemented statutes on the books, some of which provide for a safe harbor for companies who conduct a good faith, reasonable pay audit before any lawsuit is filed, and then make reasonable progress in eliminating prohibited wage disparities. So just sort of the most important thing to note there is that it's really important to think about engaging outside counsel early on, because protecting the attorney-client privilege in these situations is really key to being able to give the information that you want to give, as opposed to having someone come in and look at everything that you've done to dig into these areas. We're expecting some changes to independent contractor and joint employment regulations, so keep an eye out for those. Last slide, I think, Ann Tyler. I'm trying to finish really quickly. Watch out for changes to union organization rules. There's a new Department of Labor head. As a former labor leader, the NLRB and the NLRA are very focused on this. And then the last thing was just we're seeing more wage and hour litigation focused on the compensability of COVID screening time. So sorry I have to rush through. That's all I have right now.
We appreciate it. I know that was an ambitious amount of information to try to fit into
overly ambitious
45 minutes. Exactly.
My apologies, Jennifer. I think I took up a little bit more time than I had expected. So my apologies. So much to talk about.
No apology needed. No apology needed.
That's the end of our program today. Ann, Tyler, and Jennifer have offered to stay on. So if